All right. Court of Appeal in the Fourth District of the State of Florida is now in session. The Honorable D.W. Berger, Judge, presiding. All persons having business before the court draw near to give attention and you will be heard. And God save the United States of America and the State of Florida in this honorable court. Please be seated.
Good morning and welcome to a session of oral argument here at the 5th DCA. Marshall introduced me to everyone, but let me introduce to you the rest of the panel. To my right is Judge Edwards, to my left is Judge Jacobus, and we are honored to be presiding over the cases on the calendar today. Two of the cases have been removed from the calendar, Frank Grant versus Branch Banking and Trust, and Larry and Laurie Dobson versus U.S. Bank National Association. So if there's anybody here for those cases, they have been canceled. We have 3 civil cases on the calendar today. Each side will have 20 minutes. If the appellant will let me know how much they would like in rebuttal before we begin, I will set the clock. Also, if anyone has a cell phone on, if you will please do me the favor of putting it on vibrate or off or silent, some way that if it starts to ring, we don't hear it and it doesn't disturb the proceedings. And with that, we'll begin with our first case, which is KRISTEN Barnes versus Orlando Rehabilitation Group.
Good morning, Your Honors. Michael Lorado from Tampa, Florida. I'd like to reserve 5 minutes of my time.
Okay.
In this case, we're seeking a reversal of an order of dismissal with prejudice following a motion to dismiss on statute of limitation grounds. The error in this case, I believe, is clear on the record because the lower court applied the wrong standard in ruling on a motion to dismiss on summary judgment grounds. The rule is clear and the procedure is clear. Where a complaint merely suggests the possibility that facts could be pled in avoidance of a statute of limitations, the appropriate procedure on a motion to dismiss is to deny the motion to dismiss, and because statute of limitations is an affirmative defense which can be waived, and the defendant in this particular case below had the burden both to prove and plead that, the appropriate procedure is...
Let me ask you, the statute ran on April 5, right?
There's no question in this particular case that...
The complaint was filed late, no question about that.
No question about that, but I think importantly from this particular case is the complaint as it was filed had 2 counts. One was the statutory cause of action there, and the second was a declaratory judgment, which on its face did more than suggest that the plaintiff could prove avoidance of ultimately plead facts that were in avoidance of the statute.
What would that be? That there was a longer statute of limitations?
No, there was the declaratory judgment action specifically alleged equitable tolling and equitable estoppel, which are both...
The equitable tolling would be the letter that was dated April 4, but you got on April 12?
There were other facts in addition alleged. I think the important point is not what actually was pled, but what could have been pled. And the point is that the declaratory judgment action suggested more than that. It pointed out that there were 2 bases in avoidance. And importantly, I think it's important to note that the statute of limitations this court has held, and every other district court has held, that is an affirmative defense which can be waived. And there were facts in this case which established a potential waiver that could have been pled. There were facts which could have alleged, and I believe did in the declaratory judgment action. And I don't think it's important to focus on what was alleged. The important point is that it was suggested, right? Right? That's what the cases say. Where a complaint merely suggests facts, the appropriate procedure is to deny the motion to dismiss, and then allow a reply in avoidance, and then allow discovery on that particular issue. In this case, that never even happened.
But didn't you attach all the relevant letters to the complaint?
Sure, but there were relevant letters attached to the complaint which suggested a basis, but more importantly, there was an important, there was a lot of things which happened in this pre-suit period. And very importantly, it's important to note on this record that the demand for arbitration and the initiation of the claim and the complaint were sent in November, many, many months before. And then what did we get?
I thought it was sent 10 days before the statute of limitations ran.
Which, the letter?
I'm talking about the original, your demand to them, I thought was sent 10 days before the original 2-year statute of limitations ran. Then you had the 75-day tolling period after that. Is that correct?
That's correct. That's correct, but that would have extended the statute of limitations
Let me
by
ask you this.
by 75 days.
It looked like to me, they demanded arbitration, they didn't want to answer, right?
They didn't want to answer.
They wanted arbitration.
Correct.
You argued against that, but withdrew that motion at some point.
No, they withdrew it.
You withdrew the motion?
They withdrew the motion.
What, to compel?
To compel.
Oh,
That's an important fact in this particular
Let me
case.
ask you this. In other words, it seemed to me from the record, I think that you all were doing arbitration, basically. Were you taking depots and stuff?
That was, there was depositions and interrogatories in the underlying case, and there was another basis to suggest avoidance
Why
of.
didn't you argue that to the trial judge?
Well, I wasn't the trial counsel below, so.
That's always a bad sign. But
Judge, what happened is from what we can see from the record in this case, is that the defendant in this case, which is another basis of avoidance of the statute of limitation, they don't file an answer, they move to compel arbitration,
Right.
and then what they do is they withdrew that,
right.
so it's no longer before the court, and they substituted it 5-6 months into the litigation for now no one's interested in arbitration. And mind you, they had served discovery in furtherance of arbitration, and they had done all that.
Right.
They moved to compel it. They then withdrew that, changing their position, substitute that for a motion to dismiss
Right.
on statute of limitations ground.
Right.
So the only thing before the court was whether the statute of limitations had been violated in this particular case. And no question that it was. No question that the complaint was, I think, 10 days late.
Didn't their February 12th letter, though, say you missed the statute, we're done?
Right. I believe that did, but then there was the motion to compel arbitration, and there was the timely initiation of the arbitration under the arbitration agreement. So here there is the notion that we could still pursue arbitration and keep the claim viable. More than that, it's an important point procedurally at this point, right? So you file a complaint. There's 20 days to file a responsive pleading. No responsive pleading ever came except the motion to compel, unaccompanied, motion to compel arbitration, unaccompanied by a motion to dismiss, by an
No, but
answer.
They were trying to, they didn't want to waive that. I mean, they didn't want to waive arbitration.
Well,
I see why they did that.
Clearly, the case law is clear on that point as well. Procedurally, once you're in suit, right, by bringing a motion to compel arbitration and filing another answer, you don't waive the right to complete arbitration.
Well,
If the statute of limitations,
worry about that, I
yeah,
think.
Judge,
I mean, that-
if the statute of limitation, I mean, this court has held that specifically, that filing a responsive pleading along with a motion to compel arbitration doesn't waive the right of arbitration. But procedurally, that's an important case, and it goes towards a defense to the statute of limitations, right? Statute of limitations is something that has to be raised or it's waived, and it's their burden to prove that, not the plaintiffs. So the idea here that we had to kind of plead around the statute of limitations or set out all of our facts to negate the statute of limitations isn't procedurally correct.
Let me ask you this. The statute the letter went out 10 days before the statute of limitations.
Correct.
So that started the 75 days.
Correct.
And then they sent the letter like on the 74th day, but they mailed it, and you get it on the 12th, so you get it late, correct?
Correct.
So you didn't know about it on day 74.
Correct, but I think that's...
So if you didn't know about it until day 84, I mean, doesn't the statute say that if you haven't heard back within the 75 days, then that's deemed to have been a rejection, and therefore you need to file the complaint?
Correct. That letter was late anyway, so it was afterwards. It could be deemed to have been a rejection when they didn't do it timely in the first instance. Then it was untimely under the statute, And that's another important fact here, right? That goes towards avoidance of the entire statute of limitations. Because after they missed that deadline and statutorily were deemed to have rejected the claim, they wrote a letter, right? Now, mind you, we didn't get it until after the statute of limitations
But the
came.
letter came after the statute of limitations had run, so weren't you obligated to file within that statute of limitations absent the letter? I mean, if you'd gotten the letter on the 4th, we might be in a different situation.
Right. Statute 400 also has certain extensions of the statute of limitations. Now, one of those are when negotiations are terminated, right? So that would have extended it an additional time frame. But here, there is the whole idea that we are possibly proceeding to arbitration, that they're interested in doing that. Now, mind you,
How
that
did
may...
y'all respond to their demand for arbitration?
That may, in the trial court, it was opposed, but statute of limitations wasn't raised. So the important point is here, I think that there are facts which do suggest several theories to avoid the statute of limitations. There are many, and the point is, if there are, the proper procedure is not to adjudicate
But
the declaratory...
It seems like a lot of those facts were known at the time of the motion to dismiss.
Assuming that they were, it's still not the plaintiff's burden to plead facts.
To me, if you had argued that, look, Judge, they filed a motion to compel arbitration, and we've been doing depositions and interrogatories, I think that clearly is a waiver to me. I mean, it would be. But it wasn't argued. I have the trial judge.
Judge,
y'all were hung up on the equitable estoppel stuff.
I think that what we need to focus on is that procedurally, it wasn't ripe at that point. So how can you raise something that procedurally...
It wasn't ripe when you're looking at a motion to dismiss on failure to, on a statute of limitations defense that's apparent on the face of the complaint. I mean, that's a problem.
Judge, I understand that it's apparent. This court has held that it's only the extraordinary case that happens. And there's been one case which summary judgment has been allowed on a motion to dismiss. And the reason proffered in that case was that the attorney was one day late because he was assisting another lawyer whose tires had been slashed. And this court held that that's the extraordinary case. But in every other opinion of this case, of this court, every one, they're cited in my brief, every single one, where a complaint merely suggests the possibility of an avoidance, summary judgment, dismissal with prejudice is not appropriate. And I would submit to you that the case law goes even further. Dismissal without prejudice would not have been appropriate in this case. If there was a pleading issue and it was the plaintiff below's obligation to plead all the facts in avoidance.
You did ask the trial court to do it without prejudice, which she did, right? And then you all appealed, and then we said, well, it's not a final order. Then you went back down and got it with prejudice.
Judge,
to appeal the issue.
It was clear, the trial court's ruling was clear, and there were two bases for the ruling. There were two bases, only one of which is on appeal here. The trial court below held, and I forget exactly what the issue is, was that 400 was the only exclusive remedy.
You were saying negligence is 4 years.
Right. So there was some issue back and forth on that, but the trial court's ruling on the statute of limitations was pretty clear.
But she did it without prejudice, where you could have filed, as you suggest, an amended complaint that maybe fleshed out some of these things.
It should have been, that should have been, essentially I want to say that not even an amended complaint was appropriate, because that goes against all the case authority. The plaintiff does not have to negate affirmative defenses.
Right, but where you put it, I agree with you that that's a general statement of law, but to your complaint was attached everything in the world the judge needed to look at. And, again, when you had the opportunity, I say you, when plaintiff had the opportunity to come back and, if it's without prejudice, that's essentially the opportunity to amend your complaint. And instead of amending the complaint, take an appeal and then request request a final order that dismisses it with prejudice, essentially. You know, all those great arguments that you're talking about that could have been made by counsel were waived.
At this point of the proceedings, you have to recall that this statute of limitations was not even an issue, and the case was being litigated. There was interrogatories, there was discovery.
It was at issue at the time that they filed their motion to dismiss, and none of these arguments were made to the trial court. And we are an error-correcting court. We have to give the trial court an opportunity to correct any error beforehand.
On de novo review, I would submit to you all that you all have the record, and this case is reviewed de novo. And if the record suggests, based on this de novo review, this isn't an abuse of discretion type of case. And so the issues were preserved. There was a motion to dismiss. There was a motion to dismiss.
How did you preserve the fact that you were litigating? Basically, you were arbitrating. In other words, that how did you preserve the waiver argument?
That's point two of
the way. In other words, by their conduct, they said, "Hey, arbitrate. You're taking depots and doing all that stuff," but it was never raised with the trial court.
There was substantial argument on the.
I read the record on the hearing. I didn't see it, but maybe.
I believe there was a response to the motion to dismiss, which was filed in the case and addressed those issues. Nevertheless, on the motion to dismiss, the trial court had before it a declaratory judgment action suggesting two possible bases in avoidance of the statute of limitations. And if that's the case, how do we get around the rule?
What were the two? What were
it was equitable tolling and equitable estoppel.
Yeah, they were both the equitable ones.
Yeah.
But see, the problem with that is you didn't know. You know, I mean, I could see it, but the problem was you didn't know it until after the statute ran. That's with clear and convincing. That's a clear and convincing evidence standard.
Of course, but wouldn't discovery have permitted us to find out why they didn't statutorily comply with the 75-day period, and they allowed that to run? And then on top of that, 2 days before the statute of limitations, send out a request for discovery, and then once they filed the lawsuit, compel arbitration instead of raising the statute of limitation.
But how did you change your position before the statute ran? That's the whole issue.
Well, here what we have is an initiation of arbitration pursuant to the arbitration agreement. That's one point, which was timely done. No question about that. We have the defendant in this particular case seeking to comply with the arbitration by, mind you, forget the fact that we didn't receive it in time. That's a statute of limitations issue. Now, mind you, the arbitration is still alive. Now, we have them seeking arbitration discovery before the lawsuit and before the statute of limitations, regardless of whether we filed the lawsuit later.
And you're in your rebuttal time. I just want to let you know that.
Okay,
You can finish your answer.
I'll reserve the rest of my time.
Okay.
Thank you.
Morning, Your Honors. Amy Christensen on behalf of the Appalachee Orlando Health and Rehab. I'd like to address the court's question regarding the motion to compel arbitration. I think there's a factual discrepancy as to why we filed the motion to compel arbitration. Originally, we were operating under the assumption that there was a valid agreement to arbitrate. The agreement was signed by a DCF investigator on behalf of the minor child. Initially, we thought that that was the person who was the legal guardian of the child that would have had authority to sign the arbitration agreement. The discovery that we propounded was not in arbitration. It was related to the validity of the arbitration agreement itself.
Was that because of their response?
No, we did that first.
That was they were opposed to it in their response.
Right.
Did they raise that?
No. Yes, one of their bases was that there was no valid agreement to arbitrate because the proper people didn't sign.
Okay.
So the only discovery that we propounded was related to what was the authority of this person who signed the agreement. Are you contesting that the agreement was not valid? That's the discovery that we propounded. Never once did we attempt to litigate the merits of the case in arbitration. It was all surrounding the validity of the agreement itself. When it became clear to us that the person who signed the arbitration agreement on the minor child's behalf did not have the
Didn't it become
authority.
clear to you when they filed the complaint, the statute ran?
That became clear, but to move to compel arbitration, that would have been an issue
That'd be
raised.
the end of the case. I mean, why would you go on and do anything else?
Well, if we had a valid agreement to arbitrate, I think that would have been an issue for the arbitrator to decide.
Well, what, that the statute ran?
The statute of limitations would have been an issue for the arbitrator. It was an issue of the validity of the agreement to arbitrate. We initially do that when we see an arbitration agreement. It was whether that signatory had the authority to sign.
Typically, you want to arbitrate, they don't. I mean, that's the way it works, right?
Right,
I mean, that's all the cases are about.
right.
Okay.
So we withdrew the motion to compel arbitration when it became clear to us through the discovery, through us researching who this person was who signed, that there was no valid agreement to arbitrate, that we couldn't pursue that. So we withdrew it, and we filed the motion to dismiss based on the statute of limitations. And the important thing to remember about the statute of limitations argument was there was this time frame where there was nothing done. It is conceded in the complaint, in the sworn declaration of the attorney who filed it, that we are beyond the statute of limitations. It was February 5th, that was the statute of limitations period. They also concede in the complaint, which conclusively establishes they didn't receive anything from me, no participation in pre-suit, nothing, until February 12th. So the question becomes, from February 5th till February 12th, where are they being reasonably prudent with regard to their rights? Are they filing a lawsuit on the 5th, the 6th, the 7th, the 8th, the 9th, the 10th, the 11th, the 12th? No, not even on the 12th, because the 12th they get my letter. That-
April 12th? April, wasn't it?
February.
February.
February 12th?
Is February.
Okay.
February 12th, they get my letter. It's a standard form, and I'll explain that also. It's a standard form pre-suit letter.
File a motion to compel arbitration April 27th.
Right, because the complaint wasn't filed till the 26th.
Oh, okay.
So that's another issue, is that we've got this gap where the 7-day gap between the time that they missed their statute of limitations and got my letter. So there's that gap where they did nothing. Then they get my letter, and do they file suit at that point? No. They write me another letter asking if that was a resurrection of the statute of limitations. Then they wait. They don't file.
You said no.
I said no. They got that on the 16th.
Oh.
In no uncertain terms of February. And in no uncertain terms does that letter on the 16th state that in no way did we attempt to resurrect any already expired limitations
So when
period.
they filed a complaint, you got served on the 26th, is that or was filed the 26th?
It was filed on the 26th.
I guess you got it, because you filed on the 27th, the motion to compel.
Correct.
Arbitration.
Correct.
And you already knew the statute run, correct?
Correct. But we filed a
Why
motion.
would you compel arbitration?
We initially were operating under the assumption that there was a valid agreement to arbitrate. That's what we do when we see an arbitration
Wouldn't
agreement.
the statute still have run? I mean, I guess that I'm confused on that.
I guess it was an abundance of caution so as not to waive anything. We just,
Lulling them into some thought that maybe we're going to arbitrate.
well, that might hold water if after the 16th they got my letter, they didn't file on the 17th, the 18th, the 19th, the 20th, all the way to the 26th. They still didn't file the lawsuit. There's absolutely no reliance on anything I did in their failure to miss a deadline.
And then they opposed arbitration.
And then they opposed arbitration, indicating to us, again, saying there was no valid agreement to arbitrate, that it was a violating public policy, that it was an unconscionable agreement that shouldn't be enforced.
All this stuff.
All the good stuff.
All right.
So,
But then you start some discovery about the arbitration agreement, I guess, right?
yes, asking them to admit that this is a valid arbitration agreement, identify who the signatory is, did this person have the legal authority to sign? That's the only discovery that was done. So it can't be said that I'm lulling him by participating in any type of merit-based discovery. It's all based on the making of the agreement. Then that motion was withdrawn when it became clear that there was no valid agreement to arbitrate.
Or would it be because it's clear the statute run? Could be either, I suppose.
Could be. And then I filed the motion to dismiss based on statute of limitations. And the only thing, the other record issue I wanted to clear up, the only thing that was argued in the response to the motion to dismiss on statute of limitations was equitable tolling and equitable estoppel. The waiver arguments that the appellant is presenting to this court, those were not in the written response, and they weren't argued to the trial court below. And I've argued in my brief that those were not raised and shouldn't be considered.
They're raised on appeal.
They're raised on appeal. But even my filing of the motion,
De novo review, can we still look at it or not?
you can still look at it. I would argue to the court that they don't serve as a basis for avoidance. Just filing a motion to compel arbitration doesn't mean that you can avoid the statute of limitations. Now you can't come back and say, oh, wait, we filed a notice of intent, we want to arbitrate now, we really want to arbitrate now, when you've taken every single position that was inconsistent with that right, from the very filing of the complaint to the response in opposition. So that right can be waived. That's just kind of a last-ditch effort, I think, to try to resurrect a claim that was time-barred through no fault of the appellee.
The original February 4th letter from you was not a denial of the claim. It was seeking discovery, which, if you were plaintiff's counsel receiving that within the statute of limitations, you would go, okay, we're going to contest this and we're going to have discovery. You mentioned that that was just a form letter that y'all send out. What's the import of that?
Well, if we were here and he had received that letter with time remaining on the statute of limitations, I think they would have a good argument for a factual dispute. I would think we'd be here under entirely different circumstances, and I think maybe it would have been an issue for summary judgment, because it would be whether he relied on that. Looking at the actual letter itself, did the language indicate something that he could rely on to kind of lull himself into not filing on time? But that's not what we have here. It was received 7 days after he had already let that time period run.
And the lawsuit was filed when? On, you said April 26th, or was it February?
February 26th.
February 26th. Okay.
If your honors don't have any more questions, then I'm finished.
Okay. Thank you.
I can't stress the importance here that this was not a summary judgment. And essentially, that's what
The motion to dismiss.
it was, a motion to dismiss, and the allegations of the complaint have to be accepted as true. And of course, the notion that a party is required to completely and totally plead in their complaint all facts. What I think is clear is that there was this pre-suit period, and the attorney below for the appellant was timely made the claim. When they got the letter, said, look, is this an extension of the period of time? And there was an important fact as well, that they had this statutory requirement to comply. Now, I understand that the statute says that if they don't reply, but the point is that
How can you rely to your detriment on information you haven't received until after the statute of limitations had run?
you can't, but it's not just that. It is the fact that there was this statutory period which lapsed without response at all, and then there was.
The statute's pretty clear that if there's no response, then it's a denial.
But there was, right?
But
There
the
wa-
response, but the problem is with the equitable tolling, and you have to rely on something, and there was nothing that you could rely on, you meaning counsel below, nothing to rely on to prevent the timely filing of the complaint.
Assuming that the lawsuit was never filed,
Right.
never timely filed.
Right.
And the only thing that counsel got was their letter requesting discovery.
Yeah.
The case would have continued and it would have been timely. So,
If they
and
got-
there
if
would,
you
we
got
wouldn't
that
even
in
be here on a
time.
statute of limitations. Assuming counsel below never filed this lawsuit, didn't file it late, and the only thing that he got was their letter, which he received late, and just out of an abundance of caution, filed the complaint just to get it in there. Assuming he had never done that, and he got their request for discovery, there wouldn't be a statute of limitations issue here in this case.
There
And
wouldn't,
they
because
recognize
if it
that
was
as
timely
well,
filed,
right?
if it was timely filed, there wouldn't be a statute of limitations.
Correct, but assuming, the fact that he didn't get it is really a non-issue and didn't rely on it. It's a red herring in this case. It's not relevant, because if he had not filed the lawsuit and would have received that letter before filing the lawsuit, we wouldn't even have a statute of limitations
Right,
issue.
because then maybe there would be an argument that you relied on the letter and that discovery was going to be pending, but you can't rely on a letter you didn't receive within the time period.
Under the statute, that letter would have qualified itself as an extension of the statute of
If you
limitations.
had
Under what
received it-
section?
Oh, Judge.
I mean, it's not further negotiations, it's not a request for mediation, it's, you know, I understand, it's a tough position you have, I understand that, but, you know, the letter that you don't get, you can't rely on. You say if he didn't file it, yeah, if he got the letter and started getting discovery stuff together and sent it to the defense, and the defense said, great, thank you, we'll get back to you, that's fine. That's not what happened.
Here's what we have. We have a statutory deemed rejection
Right.
because he didn't respond, and then we have a response saying, look, give us discovery. How does that not qualify as continued negotiations under the statute, which extends the statute of limitations?
Because you received it after the statute of limitations had run. You can't rely on something that you never received.
Now we're talking about statute of limitations.
Well, that's because
Right.
that's what
But-
this case is about.
But for purposes of the statute, that letter was sent one day before the statute.
And your
expired.
and the appellant's letter was sent 10 days before the statute of limitations was run for them to do all their discovery.
Yeah, well, we got a 75-day extension.
But you do, you
Yeah.
did. You
So,
did.
They didn't do anything.
Just in conclusion, and I see that that I'm over on my time.
Time
but
is out.
Just in conclusion, it's inappropriate, I believe, to apply a summary judgment standard and to give a summary judgment based on where there is a suggestion, there could be a suggestion of lulling. No discovery was allowed to be taken on that. It's there, but to grant summary judgment at that point, to grant the motion dismissed with prejudice was the equivalent of a summary judgment. It was inappropriate, and it should be reversed. Thank you,
Thank
Your
you.
Honor.